25 minutes after 7. Good to have you with us here on the Monday edition of the South African Morning. You have a good weekend. Hope it wasn't too cold. It is going to get a bit warmer, I hope, this weekend. Now, there's a bit of uncertainty around whether the inquiry into the public protector's fitness to hold office is going to go ahead. This has been going on for some time, hasn't it? Parliament's set to appeal the Western Cape High Court's ruling, declaring that certain sections of its rules for the removal of heads of Chapter 9 institutions is unconstitutional. Now, what does it actually mean? Accountability Now sought a declaratory order that Busisiwe Mkhwebane is no longer fit to hold office. It's always a pleasure. Advocate Paul Hoffman from Accountability Now speaking to us from Cape Town. Advocate, good morning to you, and I'm going to beg for your indulgence for a moment. Viewers who might not be following this too closely, what exactly are you asking for in this? Briefly, if you could.
Yes, the situation at the moment is that there is litigation between the public protector as applicant and Parliament as respondent. And in that litigation, the High Court in Cape Town has ruled that the presence of a retired judge on a panel that was convened to see whether there's a prima facie case of misconduct or incompetence ought not to have served on the panel because of the doctrine of the separation of powers between the judiciary and the legislature. And it has also ruled that the regulatory regime that Parliament has put in place for inquiries of this nature should be one in which the public protector is entitled to have legal representation when she is put on the carpet eventually by Parliament. And these two aspects of the matter are now the subject of debate, and Parliament is seeking advice from its legal advisors as to whether they can carry on regardless or whether they should stop, or, and I think the third alternative or the third choice is the one that is probably the most appealing, whether they should scrub what they've done so far and start again.
Why is that the most appealing, Advocate? Forgive me, Advocate. Why is that the most appealing?
Well, yeah. The starting again is the most appealing because it avoids the delays that are involved in further litigation around the subject. If Parliament decides to appeal, bearing in mind that the term of office of the Public Protector ends in 2 years, in October 2023, it's perfectly conceivable that an appeal to the Supreme Court of Appeal and from there to the Constitutional Court will take up all the time between now and the end of her term of office, which will mean that the entire process would have been a waste of time. So if they start again and adjust the rules to comply with what the court has said, or the victories that the public protector has won, then it is going to be more difficult for her to pursue what Jacob Zuma likes to call a Stalingrad strategy designed to just spin out the dispute until the end of her term of office.
And that's what many critics, including yourself, Advocate, are suggesting. It's a case of dragging this out for the next 2 years. 2 years can vanish very, very quickly. I'm curious, from a legal perspective, Advocate, if, as you're calling for here, this declaratory order that Busisiwe Mkhwebane no longer fit to hold office, if you are successful, what does that do for the office of the Public Protector and all the orders and judgments that she's had go in her favour? Do they fall away? Do they get reviewed? I imagine this gets quite messy.
No. What you need to understand is that the application brought by Accountability Now is done and dusted. That happened a couple of years ago, and it ended with the court declining to say that she's no longer fit for office. The court felt that that was too close to the work that Parliament has to do under Section 194 of the Constitution, which is to have an inquiry into her fitness for office, given that she is accused of incompetence and of misconduct. So that litigation is parked at the moment, and the public protector is facing charges of perjury, which will come up again later this year in the Pretoria court, and is also on the carpet at the Legal Practice Council because she is accused of being a person who's not a fit and proper person to be on the role of advocates of the High Court. So there are many ways of skinning this cat, and if Parliament wants to play a constructive role in doing so, then the best way forward for Parliament from the point of view of the time lags is to say, okay, we accept what the court has said in the recent litigation in the Cape High Court, and we will start again. We won't put a judge on the panel that we require, and we will allow the public protector to have representation in the hearing before Parliament, and that way they could get the process kick-started immediately. But it doesn't seem to be what the ANC caucus wants to do, and what the ANC caucus wants to do is to appeal, which in effect means that the entire inquiry will be kicked into touch until either the end of the term of office or very close to the end of the term of office of our current public protector.
When courts and politics collide. Advocate Paul Hoffman, thank you very much indeed for your time. Very complicated, but always a pleasure speaking to Advocate Paul Hoffman, making sense even for the layman such as myself as to what's happening now. From Accountability Now, Advocate Paul Hoffman joining us here on eNCA. Let's see what's happening.